Hello and welcome to LiveLaw Daily. I'm your host Tebuji Das, and today, July 23rd, is National Broadcasting Day, a day that celebrates the beginning of radio broadcasting in India and celebrates the role of public communication in a democracy. Fittingly, the court today dealt with issues that touched upon access to justice, transparency, education, environmental protection, and constitutional rights. So, let's get into it. Our first story today comes from the Supreme Court, where concerns over environmental protection around the Taj Mahal were balanced against the impact that regulatory restrictions have had on hundreds of small industries. The issue arose from an earlier order passed in October last year, under which the Taj Trapezium Zone Authority was barred from permitting the setting up or expansion of industries without first obtaining the Supreme Court's approval. According to the union government, that direction left more than 400 applications pending, many of them from MSMEs, including small businesses such as flour mills and paper product units. Appearing for the centre, Attorney General R. Venkatramani and Additional Solicitor General Aishwarya Bhati argued that the blanket restriction had brought industrial activity in the region to a standstill and was affecting the livelihoods and aspirations of millions. On the other hand, Senior Advocate Aparna Bhatt opposed any relaxation, submitting that arbitrary approvals by the authority had prompted the court's earlier intervention and that environmental safeguards could not be diluted. After hearing the parties, the bench modified its October 2024 order. Instead of requiring prior permission from the Supreme Court, it allowed the Taj Trapezium Zone Authority to process the pending applications, but only through a strict expert-based scrutiny mechanism. Every proposal must now be considered in the presence of one expert, each from the court-appointed centrally empowered committee and the National Environmental Engineering Research Institute. If either expert objects to classifying an industry as non-polluting, the matter must come back to the Supreme Court. The court clarified that while key environmental studies are still pending, that alone should not indefinitely stall industrial applications, provided the precautionary principle is rigorously followed under expert supervision. Our second story today concerns the Meghalaya honeymoon murder case, where the Supreme Court has cancelled the bail granted to the prime accused, Sonam Raghuvanshi. The case stems from the alleged murder of Sonam's husband, Raja Raghuvanshi, last year. According to the prosecution, Raja was killed and his body thrown into a gorge with the help of 3 persons allegedly hired by Sonam. She was arrested days later after remaining untraceable. Her bail had been granted by the trial court and later upheld by the High Court on the ground that the police had not properly communicated the grounds of her arrest. The arrest memo had mistakenly referred to one provision of the Bharatiya Nyaya Sanhita instead of the provision relating to murder, and Sonam argued that this violated her constitutional rights. The Supreme Court, however, disagreed. A bench of Justice M.M. Sundaresh and Justice P.B. Varale held that this was not a case where the grounds of arrest had not been served at all. The court drew a distinction between complete non-service of the grounds of arrest and errors in the particulars communicated, observing that only the former would ordinarily vitiate an arrest. It also noted that Sonam had acknowledged receiving the grounds of arrest before the magistrate. Setting aside the orders of the trial court and the High Court, the Supreme Court cancelled Sonam Raghuvanshi's bail. At the same time, it granted her 3 weeks to surrender and clarified that if the trial is not concluded within 6 months, she would be at liberty to apply for bail afresh. Our third story today takes us back to the Delhi High Court, where yet another petition arising out of the students' protests has reached the court, this time seeking a National Investigation Agency probe into the violence during the July 20th demonstration. The matter was mentioned today before the division bench of Chief Justice D.K. Upadhyay and Justice Tejas Karya. Advocate Barun Kumar Sinha, appearing for the petitioner, submitted that the protest had brought the national capital to a standstill and sought an urgent hearing. The bench agreed to list the matter tomorrow. So this petition, filed by Satish Kumar Agrawal, a former vice president of the Akhil Bharat Hindu Mahasabha, alleges that the protest was not a genuine student movement but part of a larger conspiracy involving political and anti-national elements. It seeks transfer of all FIRs registered in connection with the July 20th protest to the NIA. The plea names several political leaders too, including Arvind Kejriwal, Manish Sisodia, Sanjay Singh, Dimple Yadav, Dharmendra Yadav, and Chandrasekhar Azad, alleging that they instigated protesters towards violence, including an attempt to breach parliament premises. It also refers to the participation of author Arundhati Roy, alleging that her presence raises questions about the objectives behind the gathering. The petitioner has sought, therefore, an NIA investigation into the alleged conspiracy and prosecution of all those responsible for the violence and damage to public property. The Delhi High Court will hear the matter tomorrow. While all of this was happening, Prime Minister Narendra Modi today announced that the government will set up fast-track courts specifically for paper leak cases, promising swift and stringent punishment for anyone involved. In his post, he wrote, "Nothing is more important than the welfare and future of our youth. We have decided to set up fast-track courts to ensure swift and stringent punishment for those involved in paper leaks." His post ended with a warning: those who try to harm the future of our youth will not be spared. Our fourth story today comes from the Madhya Pradesh High Court, which has reiterated that a father's legal obligation to maintain his minor child does not end merely because the child's mother is earning and the child lives with her. The case arose from a maintenance dispute between a couple who have been living separately since 2019. While the family refused interim maintenance to the wife after noting that she was employed as a government servant, it directed the father, a retired army personnel, to pay 6,000 rupees per month towards the maintenance of their minor daughter. Both parents challenged that order. The High Court upheld the family court's decision. Justice Pushpendra Yadav observed that a father's responsibility to maintain his minor child continues irrespective of whether the mother has an independent source of income. The court said that the father's obligation does not automatically come to an end simply because the mother, with whom the child resides, is also earning. At the same time, the court found no error in denying interim maintenance to the wife at this stage, noting that her government employment and income were relevant considerations. It clarified that the family court had only formed a prima facie view while deciding interim maintenance, and that the parties would have an opportunity to lead evidence before the issue is finally decided. Finding no perversity in the family court's order, the High Court dismissed both revision petitions. Our next story today comes from the Madhya Pradesh High Court, where criminal contempt proceedings against BJP MLA Sanjay Satyendra Pathak have been closed after the court accepted his unconditional apology for attempting to contact a sitting High Court judge. The proceedings arose from a writ petition relating to the allegations of illegal mining by 3 companies allegedly owned by Pathak. Although he was not a party to that case, Justice Vishal Mishra recused from hearing the matter last year after recording in a judicial order that Pathak had attempted to call him regarding the case. Taking suo motu cognizance, the High Court later initiated criminal contempt proceedings. During the hearing, Pathak maintained that the call had been made inadvertently, was immediately disconnected, and was followed only by an introductory message. He also admitted his mistake and tendered an unconditional apology. A division bench of Acting Chief Justice Vivek Rushia and Justice Pradeep Mittal held that attempting to call or message a judge in connection with a pending matter squarely falls within the definition of criminal contempt, observing that no person connected with the case should directly or indirectly contact the judge hearing it. However, the court concluded that while Pathak's conduct did amount to criminal contempt, it had not substantially interfered with the due course of justice. Accepting his unconditional apology, the bench closed the proceedings but cautioned the MLA that as a legislator, he must ensure such conduct is never repeated. Our next story comes from the Telangana High Court, where a public interest litigation has raised serious concerns about the functioning of the state's right to information regime. This public interest litigation, filed by a law student and an RTI activist, alleges that despite Supreme Court directions requiring every state to operationalize an online RTI portal, Telangana's portal has remained largely non-functional. When the matter came up earlier this year, a division bench of Chief Justice Aparesh Kumar Singh and Justice G.M. Mohiuddin directed that it be registered as a public interest litigation. The petition claims that although 17,800 RTI applications have been filed through the portal, only 377 have been disposed of. It also alleges that none of the 2,500 first appeals filed through the portal have been decided. While more than 3,300 public authorities have reportedly been onboarded, the petitioner claims that only 17 authorities are actually using the system. The PIL further alleges that despite more than 1.5 crore rupees having already already been paid to the private vendor developing the portal, thousands of citizens are effectively being denied their statutory right to information. Apart from this online portal, the petition also challenges the Telangana Information Commission's failure to introduce hybrid hearings despite directions issued by the Supreme Court. It further alleges non-compliance with the proactive disclosure obligations under Section 4 of the RTI Act, which require public authorities to publish key information without citizens having to file RTI applications. The petitioner has sought directions to make the RTI portal fully functional, shift its management to the National Informatics Center, implement hybrid hearings before the Information Commission, and ensure full compliance with the RTI Act across the state. And our seventh story comes from the Delhi High Court, which has questioned whether students should lose admission to premier institutions simply because the academic schedules of the CBSE and the Joint Seat Allocation Authority do not align. The court was hearing petitions filed by two students whose admissions to IIT Delhi and the School of Planning and Architecture Delhi were cancelled after they narrowly missed the minimum class 12th eligibility criteria. Both students are scheduled to appear for CBSE compartment or improvement examinations later this month. One petitioner, an ST category candidate, secured admission to IIT Delhi after obtaining an impressive rank in JEE Advanced, but fell just short of the required marks in mathematics. The other, a PWD candidate with a recognized learning disability, missed the prescribed aggregate by just 0.2% and lost his seat at SPA Delhi. Their case is that while the Joint Seat Allocation Authority rules allow candidates whose class 12th results improve after compartment or improvement examinations to be considered for admission, the deadline for submitting revised marks is July 15th, whereas the CBSE examinations themselves are scheduled only on July 28th, making the provision practically impossible to use. Justice Jasmeet Singh observed that such an interpretation would render the rule illusory and moonshine. The court remarked that students spend hours and months preparing for admission to premier institutions and should not suffer merely because the timelines of two authorities not being in sync. It also noted that the petitioners were not seeking relaxation of the eligibility criteria, but only a meaningful implementation of the existing rules, which even contemplate creation of supernumerary seats for candidates who become eligible after revised results. Holding that the students had made out a prima facie case, the court issued notice in the petitions and listed the matter for further hearing on August 21st. Our next story today comes from the Delhi High Court, which has refused to initiate contempt proceedings against the Municipal Corporation of Delhi and the Delhi Police over allegations that public access to a park in Janakpuri was being unlawfully restricted. The contempt petition alleged that the authorities had violated earlier High Court directions by locking the park gates, imposing arbitrary timings, and planting so many saplings that children were left with little space to play. However, Justice Jasmeet Singh was not convinced. After examining photographs produced by the Municipal Corporation of Delhi, the court found that sufficient space had been earmarked both for plantations and for public use, including walking, jogging, exercising, and children's recreational activities. The court also took note of submissions that saplings planted by the Forest Department and the Municipal Corporation of Delhi had allegedly been uprooted by the petitioner and certain other local residents. It was in view of these repeated incidents that the local police had been keeping the park locked during certain hours to protect the plantations. Observing that Delhi is in dire need of increased green cover and cleaner air, the court said that it could not permit activities inconsistent with the purpose of a public green space. At the same time, it directed the station house officer to ensure that the park remains open to the public for the maximum possible duration while putting in place adequate measures to prevent further damage to the plantations. Finding no willful disobedience of its earlier orders, the High Court dismissed the contempt petition. And finally today, an important judgment from the Telangana High Court on maternity rights of women government employees. The court has held that a woman cannot be denied maternity leave for her second delivery merely because her first pregnancy resulted in the birth of twins. It ruled that the condition required a woman to have less than 2 surviving children cannot be interpreted literally when twins are born in a single pregnancy. The case involved a junior lecturer employed with the Telangana Social Welfare Residential Educational Institution Society. She was granted granted maternity leave after giving birth to twins in 2023. However, when she became pregnant again, her request for maternity leave was rejected on the ground that she already had 2 surviving children and therefore ineligible under the Telangana fundamental rules. Justice K. Sharath disagreed with that interpretation. Relying on the Supreme Court's decision in Deepika Singh and K. Uma Devi, the court observed that the birth of twins is a single biological event and not something within the control of the mother. It also noted that maternity leave is a beneficial provision meant to protect women's participation in the workforce and must therefore receive a purposive rather than a mechanical interpretation. The High Court also referred to similar rulings of the Madras High Court and noted that both Tamil Nadu and Andhra Pradesh have already modified their rules to address such situations. Allowing the writ petition, the court declared that the petitioner was entitled to maternity leave for her second delivery, directed the authorities to treat her leave as sanctioned, and ordered payment of her full salary and allowances for the entire period. And that brings us to the end of today's episode of LiveLaw Daily. If any of these stories caught your attention, you can read the full reports through the links in the description box below. For the latest updates from the Supreme Court, High Courts, and across the legal landscape in India, head over to www.livelaw.in.